Yes, in this matter, the first defendant informed court that they have agreed to change the normal sequence of cross-examination. Agreement and cites as authority the case of Tamba Pillai versus the state. In paragraph 130 of that judgment, the court obiter states that in criminal proceedings, the ordinary sequence must be followed and it cannot be departed from. Now, I want to emphasize that the judgment specifically limits its comment to criminal matters. I've searched, I was trying to search for authority on the subject in civil matters. I could not lay my hands to any, in the short time that I had, to any civil matter dealing with the issue. But in our instance, Rule 1 Rule 1, Sub-Rule 2 reads as follows. These are the rules for the conduct of proceedings in the court and for giving effect to the provisions of Article 12, Sub-Article 1 of the Namibian Constitution. And we are all aware that Article 12, Sub-Article 1 deals with the right to a fair trial. And the overriding objective set out in Sub-Rule 3 governs the application of these rules. Sub-Rule 3 says, the overriding objective of these rules is to facilitate the resolutions of the issues, of the real issues in dispute, justly and speedily, efficiently and cost-effectively as may be practicable. My interpretation of that rule is that it grants the court at least a discretion to determine the procedures that it will adopt in the hearing of civil disputes. And the ultimate guiding line, in my view, is a question of fairness. The question that I must ask is, will the plaintiff obtain a fair hearing if cross-examination doesn't take place in the sequence in which the defendants are listed? My answer to that question is it's a no. The sequence, because the purpose of cross-examination is to try and elicit and determine the truth and the veracity of the testimony presented before court. I am therefore of the opinion that it does not matter and it would not take away from the right of a fair trial if the sequence of cross-examination is changed. And I will grant leave for the defendants to cross-examine in the sequence in which they have agreed.
Please, my lord.
Yes. Yes, Mr. You may start.
Good day, Mr. Amupanda. Yes. Your witness statement says
Mr. Amupanda, I would encourage you to speak as loud as possible because I want to hear what you are saying.
May I start, Mr. Amupanda? Can you hear me clearly?
I think so.
Thank you. Now, your witness statement says you are a political scientist, correct?
Scientist.
Yes.
Let me get to it just so I'm clear.
particulars of claim as well.
Where in the witness statement? I'm with it, so we're taking the.
Your particulars of claim, sorry, says the plaintiff, Job Amupanda, an adult male person currently residing. The plaintiff is an activist and so forth and a political scientist.
Okay, so it's not the witness statement.
Yes.
Okay, particulars of claim. Where is it so that I can go to it just to verify? So that I need to see what you are.
Sorry, let me rephrase. Are you a political scientist?
Yes.
Okay. But you are not a qualified economist.
Never claimed so. I'm not.
You are not a qualified agriculturist.
No.
You are not a qualified vet.
No.
In your documents that you discovered, you do not file any documents in respect of economic issues.
The discovery bundle is there, so we could go to it so that
In
we
your
can.
witness statement, you do not deal with any economic issues.
There should be issues that I'm dealing with.
In your witness statement, you do not deal with any agricultural issues.
I do.
What is that?
Can I go to witness
Yes.
statement? So there are several agricultural issues that I deal with. One of them is, for example, the food, the meat that was taken from me by the regime, what has happened with confiscation. It's all, I understand agriculture broadly, not in a narrow sense.
Yes, you do not deal in your witness statement with any veterinary issues.
It's there. I'm talking about the red line.
You do not deal in your witness statement with any job destruction which will occur if the red line is removed or the fence is removed.
Rephrase the questions again. You are too fast. So
In your witness statement, you are not dealing with any job losses which will occur if the fence is removed.
no,
You have filed a 3-page witness statement and you read that into the record.
you are very wrong. I don't know why you have it. It's not 3 pages.
How much is it? How many?
You have it with you, I guess. But the one that I have is not definitely not 3
How
pages.
many pages is yours?
You want me to count it?
Yes.
1, 2, 3, 4, 5 pages.
5 pages. Sorry for
6
the,
pages.
sorry for the 3. In those 3 pages, you do not refer to any pleading filed of record.
What do you mean?
You don't refer to the particulars of claim, to the pleas filed by the defendant or any defendants or anything.
Usually, if I could, there should be, I don't know in which specific document, but it's common cause that issues that are of legal nature are dealt with by my legal practitioner. I do not expect to ventilate every particular questions of law.
The court bundle consists of 1,762 pages. How many of those pages did you read?
How many of what?
Of the 1,762 pages of the court bundle did you read?
Well, I don't read and start counting, so I read various documents and questions of law, as I've indicated, they are dealt with by my legal practitioners.
Did you read the witness statements filed by the defendants?
Yeah, I read several, yes.
Several of them. Did you read the trial bundle consisting of 6,837 pages?
The same answer that I gave to the first one.
What is the same answer?
That I read what I read, but questions of law are dealt with by my legal practitioners.
Are you hearing what you're saying? I read what I read.
No, that's not what I said. That's what you heard.
Yes. What did you say?
You want me to repeat it again? Do you want me to repeat
Yes,
it again?
please.
This is question 1 or question 2?
Question 1.
Okay. So the question 1 that you had previously asked with regards to the 1,000 pages. Okay, so you want me to repeat it again?
Yes. What
I
did you
indicate-
read about that?
Can I answer?
Yes.
Yes. I indicated that I've read the documents and questions of law. I left it to my legal practitioners.
So in your estimate, how many of those pages did you read?
Well, I've already indicated to you that I don't read counting how many pages I'm reading. I read for purposes of comprehension and understanding.
What is your comprehension of the defendant's case, all the defendant's case?
Is it the defendant? I understand that I'm the one who's bringing the case. They are responding to my case. I'm not a lawyer, but I'm explaining how I understand. They are responding to my case. And how you are asking in terms of what is my understanding. My understanding is to defend the status quo. They are defending the status quo. They are defending the settlers' interest. They are defending the continuity of the suffering of our people. They want to keep the status quo because it benefits the capitalist interest that funds the defendants and everybody else.
What are the facts, not labels like capitalist and so forth. What are the facts that you saw in defense of the defendant's case?
I mean,
The question is, what are the facts? Can you say which defendant? The 8th defendant, the 5th defendant, or if my learned colleague want to refer to a specific fact, at least to give the witness an opportunity to do so. Just to say what are the facts that are defendants saying is too broad and unfair to the witness, my lord.
My lord, the question is perfectly valid, I respectfully submit. I'm asking him to check whether he read anything, because I have a suspicion he read nothing.
What was the question?
So what are the facts in general put up by the defendants to your claim?
my lord, am I allowed to inquire before or I'm just obligated to respond?
If you seek clarity, you are allowed to seek clarity.
Okay. For example, I understand I'm here to assist the court and I'm providing specific answers. Is it permissible for a counsel to say, I want you to say this and don't say that? If, for instance, at the core of this case is capitalist interest in the economic question. So if my response is the capitalist interest that is being protected and I'm being told that I must answer, don't say labels of capitalism. So I need advice from court that if that's what can happen.
Unfortunately, I can't advise.
Also,
No.
because I'm being told, I don't know,
You say you want advice from me.
so that I don't go out
No.
of the way.
There are questions.
Okay.
I don't advise. Whether you are a witness or a legal practitioner, I don't advise. And all that I want, what I am going to say is this. I'm a trier of fact. I am a trier of fact. I listen to evidence that is placed before me, extract from those evidence facts which will lead me to a specific decision. That's all I can say.
Did you read, can you recall any expert's name?
My lord, there was an objection to that, to the questions. What
I made a ruling. I said, what is the question?
Yes.
Yes, and he asked the question. He's asking the question.
Okay.
Yes.
Because
Can you give me one fact that is put up by any of the defendants in opposition to your claim? Only one fact.
so obviously for me to be able to answer that, you are asking what is the response to my case and you are
Yes.
limiting me to one.
Yes, and I'm talking fact.
Can I finish? So I must be able to determine, so that we are together, what is it I understand as my case to which they are responding to. Can I do that?
No, I'm not asking you about your case, sir. You've already testified about your case. I'm asking you, can you give me one fact that is mentioned by any of the defendants' expert in opposition to your claim? One fact.
With regards to,
It seems to me that we can go ahead. Do you dispute that if the cordon fence is removed, 33,271 permanent jobs will be lost.
Yes, I dispute.
On what basis?
On several bases. One of those bases is that the government of the Republic of Namibia commissioned a study, and that study was meant to understand what will be the consequences of the total removal of this Colonial 1896 red line. The government went ahead to find out the pro and cons. One of the findings of the regime itself is that we know it's common cause that agriculture's contribution to the GDP is 6%. The government found, number one, that the removal of the red line, this colonial instrument, would lead to the increase of agriculture's contribution to GDP from, actually in the report it says 5.1% to 20% of the country's GDP. It also indicated actually in numbers how many jobs will be created,
Okay.
both nationally and also what will happen to that area of people who have been discriminated
So you
and kept out
dispute,
for 125 years.
you
Is the
dispute
answer-
the evidence that 33,271 permanent jobs will be lost.
Yes.
Thank you. You are also employed or work at the University of Namibia.
Yes.
Did you ask any of your colleagues there to assist you to file a witness statement on the economy of this issue?
I'm in court to vindicate my rights and how I will proceed with my case. I came to court to indicate to court that in 1896 a colonial instrument has been put in place. That colonial instrument stayed on through the German colonialism, South African colonialism, and it continues. In my view, it violates rights, and I'm coming to court to vindicate those rights.
Yes.
And those rights are not dependent on what anybody else think, because we are living in a constitutional dispensation. I didn't find it necessary to be able to do that.
That's
Where I found it necessary, my legal practitioner and I had composed a list of witnesses to be the necessary documents that were submitted in discovery to be able to advance that case. So the case that I'm bringing to court, not what you or your clients think I must conduct the case.
Yes. So you did not, the question is answered as follows. You didn't think it necessary and therefore you didn't ask any of your colleagues to assist you with testimony.
Because I'm very clear in terms of my case, what this is about.
Thank you. And that also goes for any health science and veterinary medicine. You didn't think it necessary or to ask anyone to assist you.
So, when, for instance, when I read these documents of your clients and the clients of the regime and everybody else, they seem to think this case is just about meat and animals.
What is, sorry, yeah?
They think this is all about meat and animals and what they are going to use and what they are exporting to Chinese and Europeans. And the core of this case is also dignity. It's about continuity of colonialism. It's about a colonial instrument that the Minister of Agriculture says that it is the most, he speaks about the book that writes about this history, that it is a comprehensive historic record of one of the most pivotal tools of division in colonial Namibia. So it's about dignity, it's about continuity of colonialism that is protected by the regime and other stooges of the regime that continue to discriminate 60% of the population. So it's not just about meat and Chinese and what Europeans are going to use when the colonial instrument is removed.
Look, sir, I cannot stop you to say things over and over and over, but we've heard that. So please try it. So you say that you haven't asked any colleague at the university in any department to assist you because you don't think it's necessary.
What is the question?
Well, I've asked it just now.
So I'm asking what is,
I'm saying you don't think that it was necessary and you still don't think it was necessary to ask any colleague of you to provide expert evidence to this court to assist you in your case. You say it's not necessary.
I understand what my case is, and that's why I'm called to ventilate my rights, not necessarily what other people.
Yes, thank you. Can you go to page 15 of the court bundle and your particulars of claim?
Page
15 of the court bundle.
Can you assist me?
In which volume? In which file?
Well, that
volume?
is volume 1.
Where is volume 1?
And that is, I want to refer you to your prayers.
Yeah, my question is which
no,
one?
No, that Amupanda. Remember, at the beginning, I asked the question: has your legal practitioner prepared and numbered the files for you? And the answer was in the affirmative.
Yes, because.
So you don't ask me in court now, which way is that? Because I asked that question earlier. Has your legal practitioners numbered the bundles? Have they provided you with the bundles? And the answer was in the affirmative. Okay, can my volume 1? Can I have volume 1?
My Lord, perhaps I can assist. I'm going to these documents which I will hand to him now contains that document as well. And it's an extract from pleadings in the court bundle.
Yes, if you can.
So if I may hand to your Lordship this bundle, I'll make it a separate annexer to assist in the meantime. Can I hand this to you?
What page of the particular?
No, let me help you because you.
I have it here with me.
I'm trying to help you, Mr. Amupanda.
I'm saying I have it here, my Lord.
Please okay, if you want to, look at page 15. That your Lordship will find in that bundle which I've now handed. It's the third last page. That bundle is numbered 138 at the right hand foot of the page, and I'm at page 136, which is 15 the right hand top of the court bundle. Are you there? Are you at page 15, Mr. Amupanda?
Yes.
Is your Lordship with me?
Is that the notice of exception?
Yes, wherefore the plaintiff prays for an order in the following terms. That is, these prayers in the particulars of claim. My Lord, the bundle which I've now handed to your Lordship, that particulars of claim is also contained in that little bundle, and that's if you go to the right hand foot of the page, is at page 136, which is the third or fourth last document. We've taken that from the pleadings, at the number 15 right hand top is in the court bundle 15. So that I identify for the record is the prayers of the particulars of claim which brought us to this court. Are you with me, Mr. Amupanda?
Yes.
Now let's just look at your prayer. An order, is your Lordship now with me?
Yes.
An order declaring that the erection of the veterinary cordon fence has not been carried out in terms of any law. You see that?
Yes.
That's not true.
It is my case that it is true, it is so.
Did you look at the following? Section 16(1) of the Animal Diseases and Parasites Act 13 of 1956.
And that is where you and the regime and your clients get it wrong. When we are talking about the red line, it exists at two levels. At the conceptual level and also at the level of reality. It is accepted here in this document, in the pre-trial. You and the regime and everyone has accepted that the veterinary cordon phase, the red line, has been established and created before independence.
Yes.
Let me finish. And it's been maintained. So we don't just arrive at that prayer for the sake of it. And one of the things that you and your client and the regime fail to see is that there is a word erection.
Yes.
Yeah? So erection, you are talking about the actual construction and the putting up of the red line, as we understand it.
Yes.
Let me assist you so that you can understand how and when and why the red line was erected, so that it would give a basis to what we are talking about there.
No, hang on. I don't want to be lectured. I'm asking the question. I'm saying to you, and it's not an interruption of the witness. I'm saying to you, look at your prayer 1. You say that cordon fence has not been erected or carried out in terms of any law. That also refers to pre-constitutional and so forth.
But that's what I'm trying to help you to understand. You say it is not true. I'm trying to explain to you how wrong you and the regime and everybody else who don't understand our case. I'm trying to explain to you what has happened historically. I'm trying to take you to the actual event of the erection of the fence, of the cordon fence.
When was the fence erected?
That's what I'm trying to tell you now. Allow me to.
Yes, tell us when was the fence erected?
You,
My learned colleague must allow the witness to answer the first question before he goes to when was it erected.
Well, he hasn't answered the first question.
Because you
Because
don't
you are
allow me.
All right,
interrupting and
can I
asking
get
the
order?
second one.
Can I get order? Yes, what's the question?
Which you say on page 15, Mr. Amupanda, you want this court to declare that the erection of the veterinary cordon fence has not been carried out in terms of any law.
yes,
We all know that that fence was erected prior to Namibia's independence.
yes,
And you say it was not done in terms of any law.
yes,
In other words, in terms of legislation.
yes.
And why do you say, no, sorry, I'm referring you to, first of all, the Animal Diseases and Parasites Act, which gives the old regime, those racists, those colonial racists, had a power in terms of an act to erect the fence. Do you agree with
That
me?
is where you and the regime and everybody else is wrong. That's why I'm trying to help you. Now, in the late,
object to this evidence. This opinion evidence on whether an act was valid or not, or is valid or not. The opinion of this witness on the validity of an act is immaterial for your lordship to decide.
Allowed it to be, for my learned colleague to object to the witness's testimony, especially in light of this arrangement that has been done in changing of cross-examination, my lord, that sort of objection will prejudice, my lord, the plaintiff under the circumstances.
The witness is under cross-examination. Let him answer the question.
Yes.
so
We are, can I just try and just focus, please?
I was answering,
You
my
can
lord.
answer.
No, there were many interruptions.
I'm busy with
Yes.
prayer 1, in which you want this court to declare that the fence prior to when it was erected was not done in terms of any legislation.
Yes.
Now, I'm saying to you it was.
That's why I'm trying to explain to you how you are just not allowing
Okay, so
me to.
let me hear why you say it wasn't done in terms of
Absolutely.
legislation.
Now, in the late 1800s, in the late 1880s, the disease called rinderpest was discovered in East Africa and started moving towards Southern Africa. Right? In 1896, the report started coming that this disease was rumored to be part of the Zambezi Day. Now, the colonial government at the time,
The Germans now.
the colonial government at the time, it's common cause who was the colonizing power by then, decided that they need to protect the European herd. They need to protect the cattle that belongs to the European. Okay? in August 1896, the colonial government, both the Germans and the British, met in Bechuanaland, and they organized what is called the Freiburg Conference. And the Freiburg Conference was pondering with these questions: what do we do in response to the rinderpest disease? They took quite a number of resolutions. What is it that they need to be able to do? They said all these countries, the German South African government also attended in Botswana. They took 5 resolutions. One of those resolutions is that they need to make sure they stop the movement of animals across the borders of all those member states, or countries that were present there. They also decided they need to impose a strict control of the Africans. Yeah, that's one of those resolutions. Every other country went then to go and implement. Theodor Ludwig, who was the governor of German Southwest Africa, had a problem because by then they probably, the colonial government only had about 400 to 500 people. It was impossible for them to carry out what Botswana and other countries did in terms of putting up the fence. So Theodor Ludwig sent Lindequist to go and actually set up that fence, that red line, to be able to protect the European herd. They didn't do it because of any legislation. No legislation was passed, and we are talking about, they started, Lindequist went there to physically monitor the construction of that fence from November 1896.
Are you putting facts before court, or what is it?
Well, I'm a scholar, I'm a political scientist, so I read this, I understand this.
I remember what I said to you. I'm a trier of facts. I'm a trier of facts. I am not trying history. I want facts.
Okay,
and
so
when you are putting statements to me, it must be either evidence which you can substantiate, or you can bring somebody to substantiate.
okay, my lord.
Mr. Amupanda,
Okay.
can I look?
My lord.
Can I ask you?
No, why I ask the question, I don't want to sit in court the whole day and listen. You see, what I need, as I'm saying, I need facts that will assist me to determine the dispute between the parties.
My lord, but that is exactly, I'm trying to ask a question, but if it's obvious what he decided. Whatever I ask, we're going to get a political speech. And it's hardly possible to discipline a witness in cross-examination. So I've let him now go. Can I just rephrase?
Yes.
Can I say this to you?
My lord.
Mr. Amupanda?
Okay, let me hear him. Let me hear it. Okay. Let me hear the witness.
Yes.
And I want to say something. Can we be very tolerant and just listen to each other in this meeting? Yes?
Yeah, so I you indicated, because I was answering the question and your intervention came, and I don't know what to do with.
No, I asked. You see,
yes, I didn't get an opportunity to respond.
I'm asking, and I'm asking you the question. Yes. You are talking of what Lindequist did.
Yes.
You are talking of who went where.
Yes.
So I'm just, and I want to guide you. Well, that's why I asked the question. Are you talking about factual issues that you are aware of? Are you giving me a lecture? That's all I ask.
Okay. Yes, my lord, my legal practitioner have given to you in our opening statement a copy of the book that details the history of this 1896.
Who gave me a book?
No, I'm saying my legal practitioner in the opening statement yesterday, he referred to you. He referred you to a book.
Yes.
I was listening carefully when he was doing that. So you indicated, am I giving facts? I'm indicating to you that this is what I have seen, even in terms of the book that has been referred to my legal practitioner to court. Those historical events are there, even in terms of that text that has been brought to the attention of the court. So those are facts, Your Worship.
Perhaps it's opportune time to break. I see it's past 1. Perhaps it's opportune to break now. It's a few minutes.
Okay, I see it's 10 minutes after 1. We will break for lunch. Amupanda? When is university starting?
The administrators are already there.
Sorry?
The administrators are there, so university is open.
So when are you starting preparing for lecture?
Lecture starts in February.
It's just around the corner. Yes. Now, you can speak to anybody about your preparations of lectures, how many students you will have, about the rain in the north, the non-rain in the east. You can speak to anybody about anything. But you are not allowed to speak to anybody, including Mr. Kavila, including Mr. Mkinda, on the subject matter that is before court now, whilst you are under cross-examination. Do you understand?
Yeah.
All right.
Or Facebook for that matter.
I don't know.
I don't speak to Facebook.
You are
Facebook
allowed to
doesn't
speak to. You are allowed to speak to nobody about this matter. Whether you are posting, whether you are addressing whoever, but you are allowed to speak to nobody on the subject matter of this matter whilst it's in court and whilst you are under cross-examination. Yes.
Thank you, Manoj.
Court will rise and we will resume at 2:30.